Imagine this, a loved one passes away, they own a home and everyone assumes the house just goes to their family. In reality, that's not often where the stress, confusion, and expense really begins. I'm Justin Paulino and I'm a certified probate and trust specialist. In this video, I'm going to walk you through what actually happens to a home when the owner passes away. If there's a will, if there's no will, and how different types of trusts can save your family time, money, and heartache. Whether you're a homeowner planning ahead or an heir suddenly dealing with an estate, this will give you clarity and a game plan. What really happens when someone dies owning a home? Let's start with the big misconception. Owning a home does not automatically mean it just goes to your spouse or the kids smoothly. When a homeowner passes away and that home is not in a trust, that property usually goes through a legal process called probate. Probate is a court-supervised process where a judge oversees who's in charge and ultimately who gets the property and on what terms. During probate, heirs usually cannot sell the home or change title freely until the court gives someone authority. It can take many months, often years, or more, depending on the complexity and the court's backlog. Everything is public record: who inherits, roughly what the estate is worth, and who's fighting over what. So for heirs, if you're expecting to quickly sell a home or move in, probate can be a big surprise roadblock for you. For homeowners, this is where planning ahead makes a huge difference for your family. Now let's talk about the money side, because this is where families say, we had no idea. In probate, there are typically court filing fees, publication costs, public notice in a newspaper, attorney fees, personal representative or executor fees. In many cases, those legal and executor fees are calculated as a percentage of the gross estate value, not the equity. So if your home is worth $2 million, the percentage is based on $2 million, not what's left after the mortgage. For a 7-figure home, it's very common to see tens of thousands of dollars eaten up in probate-related costs. That's money that could have gone to your family, charities, or investments, but instead it goes to the process. And remember, probate is slower, it's public, and it's more expensive than a well-designed trust-based plan in most situations. Now let's break down two very common scenarios. When there is a will, but no trust. A lot of people think, I have a will, I'm covered. Here's the truth. A will controls who you want to receive your assets, but a will does not avoid probate. If the estate is over a small estate threshold and the home is not in a trust, what the will does, it names an executor, the person you choose to handle your estate. It gives your instructions, who gets the home, whether it's sold, how proceeds are divided. What it doesn't do, it doesn't keep you out of court. It doesn't keep things private. It doesn't necessarily make things fast or cheap. So I have a will is better than nothing, but it's not the same as having things truly streamlined for your heirs. When there's no will, that's called intestate. If you die without a will, you don't avoid probate, you just let the law decide for you. When there's no will, the law decides who inherits, typically your spouse, children first, then parents, siblings, and so on. The exact split can get complicated, especially with blended families, second marriages, or kids from prior relationships. Family members may be surprised by who legally has rights to the home and in what proportion. For heirs, this can cause conflicts between the surviving spouse and children, co-ownership between people who don't get along, forced sales when some heirs want cash and others want to keep the home. From a planning standpoint, no will is basically saying, I'm okay with the government's default plan, no matter what that does to my family. Joint ownership and TOD deeds. Before we move into trust, let's briefly touch on two things that you may have heard of. Joint tenancy, community property with right of survivorship. If a married couple or co-owners hold title this way, the surviving owner usually receives the deceased owner's share automatically. That can avoid probate at the first death, but often not at the second. Transfer on death, TOD deeds. In some cases, an owner can sign a deed that names a beneficiary to receive the home at death. It can avoid probate, but it has technical requirements and can create issues in more complex family or tax situations. These tools can help in narrow scenarios, but they're not a substitute for a comprehensive estate plan, especially where there's significant equity, multiple properties, or blended families. Now let's talk about the tool most families rely on, the revocable living trust. Think of a revocable living trust as a custom set of instructions plus a new bucket to hold your assets while you're alive and after you're gone. Here's how it generally works. You create a trust during your lifetime. You typically serve as your own trustee and beneficiary while you're alive, so you stay in control. You retitle your property into the trust's name. You name a successor trustee who steps in if you're incapacitated or when you pass away. You spell out who gets the home or the sale proceeds and what terms. The key benefits: it avoids probate on the assets properly titled in the trust. Faster and often far less expensive than a full probate. Private, not a public court case. Handles incapacity. If you're alive but unable to manage things, your successor trustee can step in and manage the property without going to court. Important point that gets missed: the trust must be properly funded. If the deed to your home never gets changed into the name of the trust, that home may still end up in probate, even if your trust document is beautifully drafted. So for homeowners, the trust is the plan, but the deed is the implementation. For heirs, if you're told there's a trust, one of the first questions needs to be, is the home actually titled in that trust? Not all trusts are the same, so let's keep this really simple. Revocable living trust. You can change it, amend it, revoke it during your lifetime. Primary goals: avoid probate, make it easier on your heirs, and plan for incapacity. Generally does not give you strong protection from your own creditors or lawsuits while you're alive, because you still control the assets. Irrevocable trust. Much harder or sometimes impossible to change after it's created. You typically give up direct control and ownership of the assets placed into it. Because of that, it can, in the right situations, offer asset protection, tax planning advantages. Common uses include keeping certain assets like life insurance outside your taxable estate, providing long-term management for your beneficiaries, certain long-term care or benefit estate planning strategies when done correctly and early. For most homeowners, the starting point is a revocable living trust for probate avoidance and ease of administration. Irrevocable trusts are more specialized tools and should be designed with a qualified estate planning attorney, especially when asset protection or tax issues are the main goal. Let me quickly paint you a picture so you can see the difference. Scenario A: there's no trust, no plan. Owner passes away with a home worth, say, $1.5 million. No trust, maybe a basic will, maybe not. Heirs have to open probate, hire an attorney, wait for the court to approve everything. They may wait many months before they can sell or refinance. They may pay tens of thousands of dollars in fees and costs. Any family disagreement gets magnified because they're now inside a public legal process. Scenario B: revocable living trust in place, home titled in the trust. Owner passes away, successor trustee steps in almost immediately. The trustee can work with professionals to sell the home or distribute it accordingly to the trust instructions. No full probate, much less court involvement. The process is faster, usually less expensive, and it's private. Heirs know who's in charge and what the rules are because it's all written out for you. Same house, same family, very different experience. If you're a homeowner watching this, your home is often your largest asset. The way it's titled and the plan around it will directly impact how easy or difficult things are for the people you love. A thoughtful estate plan, usually anchored by a revocable living trust, can save your family time, money, and conflict, and keep your affairs private. Review how title is currently held on your home. If you already have a trust, confirm the home is actually in the trust. Work with an experienced estate planning attorney to make sure the legal side aligns with your goals. Coordinate that with your real estate strategy, tax planning, and overall financial plan. First, give yourself permission to take this step by step. This is emotional and complicated. Gather key documents: the deed, any trust, any will, recent mortgage statements, property tax bills, and insurance. Figure out, was there a trust? How is the property titled? Is probate required? Then talk with a professional team, an estate planning or probate attorney, a knowledge real estate professional, and potentially a tax advisor to create a plan. The decisions you make about selling versus keeping, refinancing, renting, buying out your heirs can have major financial and tax consequences. You don't have to navigate this alone, and you should. Estate planning isn't just about documents. It's about making things simpler, clearer, and more dignified for the people you care about most. If you're a homeowner who wants to make sure your family is protected, or an heir who's facing decisions about a property after a loved one's passing, I'm here as a resource. We can walk through how the home is currently titled, what probate would likely look like for your situation, and what options you have to make things smoother and more efficient. As always, I'm Justin Paulino, here to educate and navigate, not speculate and fabricate. If this was helpful, share it with someone who owns a home or someone who just inherited one. And subscribe for more real estate and estate planning insight designed to protect you and your family.